Good evening, everyone. Good evening, sir. I am Rogelio A. Caluna Jr., and I will be reporting the topics under Canon 3, Section 21 and 22. Section 21, lawyers in government service, conflict of interest. A lawyer currently serving in the government shall not practice law privately unless otherwise authorized by the Constitution, the law, or applicable civil service rules and regulations, if allowed. Private practice shall be upon the express authority of the lawyer superior for a stated specified purpose or engagement, and only during an approved leave of absence. However, the lawyer shall not represent an interest adverse to the government. So the general rule here is that government lawyers cannot practice law privately. The exception, unless otherwise authorized by the Constitution, the laws, and applicable civil service rules and regulations. However, the lawyer shall not represent an interest adverse to the government. So here are the governing laws. Section 7 of the Republic Act number 6713, or the Code of Conduct and Ethical Standards for Public Officials and Employees. And for the permission from head of agency, the Civil Service Commission Resolution number 1800-692, dated July 3, 2018, or the 2017 Omnibus Rules on Appointments and Other Human Resource Actions, or the ORA. So who are the officials who cannot practice law or can practice law with restrictions? So the following individuals or authorities are not allowed to engage law in the private practice of law. First is the judges and other officials or employees of their superior courts, of the superior courts. Number two, um, officials and employees of the office of the Solicitor General. Third is the government prosecutors. Fourth, the president, vice president, members of the cabinet, their deputies and assistants. Fifth, the members of the Constitutional Commission. Six, the ombudsman and his deputies. Seven, all governors, city and municipal mayors. And ninth is those prohibited by special law. So who are the following that are allowed to practice law but with restrictions? First is the senator or the members of the House of Representatives. Second are the retired justices or judges. Third is the civil service officers or employees. Um, Fourth is the members of the Sanggunian. Um, who are authorized to represent the government? So these are the following personals who are authorized to represent the government. First is the Solicitor General, Assistant Solicitor General. Third is the Solicitor and Trial Attorney. Fourth is the State Prosecutors and State Counsel in the DOJ. Fifth is the Provincial and City Prosecutors and their assistants and other attorneys in other legal offices of the government. And last is the any official or other person appointed or designated in the accordance with law to appear for the government of the Philippines. So next is, so here is the um re- related case. So in Fajardo versus Alvarez, AC number 9018, dated April 2016. Um, Here, the respondent is a public officer, an employee of government, and the office of the ombudsman is part of government. By appearing against the office of the ombudsman, respondents is going against the same employer he swore to serve. Thus, a conflict of interest exists when an incumbent government employee represents another government employee or public officer in a case pending before the office of the ombudsman. The incumbent officer ultimately goes against government's mandate under the Constitution to prosecute public officers or employees who have committed such acts or omissions that appear to be illegal, unjust, improper, or inefficient. Furthermore, this is consistent with the constitutional directive that public officers and employees must at all times be accountable to the people, serve them with utmost responsibility, integrity, loyalty, and efficiency, act with patriotism and justice, and lead modest lives. My next topic will be section 22, public attorney's office conflict of interest. Here the public attorney's office is the primary legal aid service office of the government. In the pursuit of its mandate under its charter, the public attorney's office shall ensure ready access to its services by the marginalized sectors of society in a manner that takes into consideration the avoidance of potential conflict of interest situations which will leave these marginalized parties unassisted by counsel. A conflict of interest of any of the lawyers of the public attorney's office incident to services rendered for the office shall be imputed only to the said lawyer and the lawyer's direct supervisor. Such conflict of interest shall not disqualify the rest of the lawyers from the public attorney's office from representing the affected client upon full disclosure to the latter and written informed consent. Um, this provision is a new provision in the CPRA. The foregoing rule strikes a balance between access to justice and the need to preserve the fiduciary relationship between the lawyer and the client. The CPRA recognizes that unlike other clients who can seek legal assistance elsewhere, should their counsel of choice be unable to represent them due to a conflict of interest, indigent clients who go to the POW and legal aid organizations less out of choice than out of necessity are left with no legal representation if these entities cannot represent them. On the other hand, indigent clients must be assured of the loyalty and confidentiality characteristic of attorney-client relationships, which are essential to the administration of justice. Limiting the conflict of interest rule to the handling lawyers um, seeks to guarantee access to legal representation by the poor without compromising the fiduciary relationship between the lawyer and the client. Verily, the court adopted Section 22, Canon 3 of the CPRA in the exercise not only of its power to regulate the practice to regulate the practice of law, but also of its constitutional prerogative to promulgate rules concerning legal assistance to the underprivileged. It is well to note here that it is the PAU's principal mandate to free provide free legal assistance to indigents. So this is the relevant case that I find internet. So here the subject is the request of the Public Attorney's Office to delete Section 22, Canon 3 of the proposed Code of Professional Responsibility and Accountability. So uh, court, the court is not persuaded by the House submission that Section 22, Canon 3 of the Cpra violates the Equal Protection Clause. Section 22, Canon 3 does not distinguish indigent clients from paying clients. What the CPRA considered in making a decision under this section is the nature and purpose of the POW and those of private law firms. There are stark differences between the two, whereas a private law firm laboring under a conflict of interest can be replaced by another law firm or even a solo practitioner engaged by the potential paying client. Indigents who count solely on the POW do not have any option. So the Section 22, Canon 3 of the CPRA strip stripped to its core merely states that the POW cannot indiscriminately invoke conflict of interest in case where its services have been engaged by one of the parties when its assistance is sought by another party. Conflict of interest only sets in for handling public attorney and his or her direct supervisor. So that would be all on my end. Thank you.